There's been a shooting. The woman's voice didn't shake. The 911 recording logged her tone as measured, composed. She provided her name, the address, and the statement. He tried to hurt me. I shot him. The call came in just after 5:23 p.m. on a Sunday. Within 8 minutes, Manatee County deputies arrived at the home in Lakewood Ranch, Florida, a quiet, manicured suburb less associated with emergency sirens than with golf carts and lawn service schedules. The front door was slightly ajar. The woman stood just inside, unarmed. She held both hands visible at chest level. A black handgun rested on a console table behind her. There were no screams, no signs of resistance. The officers instructed her to step outside, which she did without hesitation. I had no choice, she told them. Inside the sunroom of the 2-story stucco house, 58-year-old Douglas Benefield lay face up on the tile floor. His legs were angled, his right foot twisted unnaturally. His eyes were open. There was a small pool of blood forming beneath his torso, extending slowly across the grout line. EMS declared him deceased at 5:49 p.m. 2 visible wounds were noted. One entry point at the upper thigh and a second, more critical, through the left forearm, penetrating the upper chest. The path of the fatal bullet indicated it passed through muscle, shattered bone, and tore into the heart's right ventricle. Death would have followed in minutes, if not seconds. Deputies secured the scene and initiated body cam documentation. The responding officers remarked on the unusual calm. Furniture was untouched. No blood spatter outside the immediate area. No broken glass, overturned chairs, or visible struggle. The firearm, later confirmed to be a 9mm semi-automatic pistol, was free of fingerprints. Neither the grip nor the trigger bore smudging. 2 shell casings were recovered, one near a baseboard by the far wall, another beneath a nearby bookcase. A black gym bag in the foyer held no weapons or personal belongings. Doug's keys were still in his pocket. No wallet was found. The woman identified herself as Ashley Byers Benefield, 28 years old, the legal spouse of the deceased. She stated she was acting in self-defense. She did not request an attorney. She did not attempt to flee. In her words, "He came at me. I warned him. He didn't stop." Paramedics reported no injuries on her body. No defensive scratches, no bruising, no torn clothing. Her hands were clean. Her heart rate, taken via pulse oximeter, registered 72 beats per minute, within normal range. An officer later noted in the incident report, she was calm, not dissociative, not shaken, clear-eyed. She had already decided what narrative to present. The victim's clothing was intact. He was dressed in pressed khakis and a light polo shirt, no jacket, no belt removed. He wore no shoes, no blood was found on his hands. Under his fingernails, there was no evidence of skin cells or foreign material. No signs of an altercation were observed on the victim's person. A forensics team began processing the interior. Trajectory analysis estimated the fatal shot came from approximately 6 to 8 feet away. There was no gunpowder stippling on the victim's shirt or arm, suggesting distance firing rather than close contact. The path through the body aligned with a shot fired from mid-height, level, not downward or upward. That contradicted the narrative of a struggle or a fall. Blood pooling was contained. Drag marks were absent. One anomaly became apparent during canvassing. The Ring doorbell mount was present, but the camera unit had been removed. A search of connected smart devices revealed the home's Ring account had been disabled from its original login just 10 days prior. The feed had been inactive since. There was no footage of Doug entering the home, but a neighbor's external security camera picked up his SUV arriving at 5:08 p.m., roughly 15 minutes before the 911 call. No other visitors were recorded, no signs of forced entry. Doug's vehicle showed no damage. The driver's door was unlocked. A half-full water bottle sat in the cup holder. His phone was found inside the house, on a counter near the kitchen, face up, still unlocked. When questioned about why the door camera had been removed, Ashley said only, "I didn't feel comfortable being watched." She declined to elaborate. The hardware had not been located within the house. Investigators later obtained a warrant to search the trash bins and nearby property. Records checks revealed no prior domestic disturbance calls to the address. There were no protective orders, no documented police interactions between Ashley and Doug in the state of Florida. However, a more thorough inquiry into family court filings uncovered a recent petition Doug had filed for primary custody of their daughter, Emerson. The motion, dated 3 weeks before the shooting, alleged that Ashley displayed erratic and paranoid behaviors including threats to isolate the child and sever contact with extended family. The filing was set for review the following month. A copy of that petition was printed and added to the evidence file. Detective Harrison, assigned as lead, commented internally, "If someone files for custody, then ends up dead in that same month, you start by pulling every record that ever mentioned their state of mind." The responding medical examiner noted additional details. Doug's Apple Watch had logged a step count consistent with walking from the car to the house and then briefly around the living room. At 5:17 p.m., all biometric tracking ceased. That timestamp would later align precisely with the fatal cardiac trauma. Initial statements from Ashley were brief. She said Doug was verbally aggressive, claimed he said she'd never see Emerson again. She repeated, "I was afraid." But she did not claim physical assault. She did not describe any specific motion that would suggest Doug had lunged or reached for the weapon. A curious aspect of the scene, the placement of the firearm, was noted in several officer reports. It was not dropped or discarded. It was placed, barrel angled away, magazine ejected, the slide locked open, all steps indicating the weapon had been disarmed following use. That level of post-incident control was rare in panic-based shootings. Investigators didn't say it aloud that night, but they noted it in margin comments. This didn't look like a sudden, chaotic act. It looked managed, deliberate, clean. Before Ashley was taken in for further questioning, she asked if she could call someone. She did not ask about Doug's condition. She did not ask if he was alive. Her only question was, "What happens to my daughter now?" No tears, no hysteria, no remorse, just silence as the cruiser door shut. In cases involving domestic homicide, investigators don't start with the crime scene. They start with the relationship. And when a couple marries after 13 days of knowing each other, when one partner is twice the age of the other, and a legal custody battle is underway at the time of death, that relationship doesn't just get examined, it gets dissected. Douglas Benefield was 54 years old when he met 24-year-old Ashley Byers at a political fundraiser in 2016. It wasn't an unusual setting for him. He had long-standing ties to conservative circles and a background in defense contracting. What drew him to her, as described by acquaintances, wasn't just her appearance or youth. It was her ambition. Ashley was a former ballerina with the American Ballet Theater. She had recently left professional performance following injuries, but she hadn't left the world of dance. Her goal was to establish a new ballet company, something that, in her words, would reclaim the soul of the art. Doug didn't hesitate. Within 2 weeks, they were married. Friends from both sides were either excluded or blindsided. Doug's teenage daughter from a prior marriage was reportedly not informed until after the wedding had occurred. Ashley relocated into his home in Charleston, South Carolina. Doug funded the launch of a new venture, the American National Ballet. The project was ambitious, with aspirations of rivaling traditional coastal powerhouses in the arts. Doug leveraged business contacts and invested over $300,000 in startup costs. Ashley positioned herself as artistic director. Within months, it collapsed. According to court filings later reviewed by law enforcement, nearly 24 dancers were hired without contracts. Salaries went unpaid. A flurry of lawsuits followed. One investor described the environment as chaotic. There was no operational leadership. Ashley made every call, and no one could question her. That was not a quote offered for public consumption. It was pulled from a 2017 civil deposition, which investigators obtained following Doug's death. What began as a romantic partnership quickly transitioned into a business partnership, and when the business failed, the marriage began to erode. Internal family court documents from 2019 indicated that Doug had relocated part-time to Florida. Ashley remained with their infant daughter. In his affidavit, Doug cited emotional volatility, verbal aggression, and erratic behavior on Ashley's part. Ashley counterfiled in Florida court, asserting that Doug was controlling, financially manipulative, and emotionally abusive. Neither filing included allegations of physical violence. The background check on both individuals returned no prior criminal history. Ashley had a single civil judgment related to the ballet company's debt. Doug's record was clean. His military discharge had been honorable. He had worked for the Department of the Navy and later transitioned to private consulting. But it wasn't the resumes that interested the investigators. It was the digital pattern. In the weeks leading up to Doug's death, he had been sending text messages to friends describing increasing concern for his safety. He wrote to a confidant, "I'm trying to get custody, but I don't feel safe walking into that house alone anymore." That message was dated 9 days before the shooting. Ashley, meanwhile, had texted a friend, "Doug's trying to take my baby. I will never let that happen. Never." When presented in court, such statements would take on heightened significance. But for now, in the investigative phase, they served as early motive indicators, not proof, but context. An examination of both phones was conducted under warrant. Doug's calendar showed the visit to Ashley's residence on the date of the shooting as a scheduled custody exchange. There were no notes of alarm, no protective measures scheduled. His last text, sent at 5:06 p.m., simply read, "Here." Ashley's phone showed a message thread to a confidant the night before. It included the phrase, "I just hope he doesn't push me tomorrow. I'm too close to the edge." These messages didn't yet prove intent, but they sharpened the psychological profile. Investigators began to construct a behavioral timeline, not based on assumptions, but on verifiable communication patterns. Financial records revealed another wrinkle. 2 weeks before the shooting, Doug had initiated the process to remove Ashley from a joint trust. He had also modified the beneficiary designation on a life insurance policy. That policy, valued at $500,000, had previously listed Ashley as the primary recipient. It was changed to his daughter. The change was not yet finalized at the time of his death. When presented with this information during a second round of questioning, Ashley stated, "I didn't know about any of that, but even if I had, it doesn't change what happened. He came after me." She did not elaborate. Investigators flagged one more item from Ashley's history: a 2020 medical consultation regarding postpartum anxiety. Notes from the attending psychologist included language like "exhibits hypervigilant tendencies" and expresses intense fear of losing custody. These notes were protected under HIPAA but were accessed following Ashley's waiver of privilege during voluntary questioning. Detectives began assembling a forensic profile, not of blood patterns or fingerprints, but of behavior, stress escalation, and possible pre-incident rationalization. Ashley had begun researching Florida's Stand Your Ground statute in the months leading up to the incident. That was confirmed by browser history, search terms including legal self-defense Florida, what counts as imminent threat, and custody rights and abuse cases were recorded multiple times in August and early September. This wasn't conclusive of planning, but it wasn't benign either. It was Detective Renner who voiced the quiet doubt first during a post-briefing summary. When someone studies the law that precisely right before a shooting, it either means they're afraid something's coming or they're preparing to explain something that already is. The focus of the investigation began to shift. The death scene had been suspicious for its sterility. The marriage, now fully unpacked, raised further questions about who was losing control and how far they might have gone to regain it. Ashley's version of events was clear. She acted out of fear. But the data kept aligning with clean sequences, not chaos. Clean sequences were rarely born of panic. The homicide unit requested a timeline reconstruction from digital forensic analysts, aiming to cross-reference text exchanges, GPS data, and home device interactions down to the minute. The goal wasn't to disprove fear. It was to establish whether the threat had actually occurred or if it had only ever existed in theory. As of the close of day 3, investigators had no physical evidence of forced entry, no witness statements supporting violence, and no forensic indicators that Doug had been aggressive. But they had motive, they had custody filings, and they had a house full of silence that didn't match the story being told. This wasn't just about a shooting anymore. It was about intent. 3 days into the investigation, detectives shifted their focus from the scene to the custody case. The physical evidence had already raised questions, but now the legal trail was opening up a clearer path toward understanding motive, timeline, and emotional escalation. At the center of everything was a 2-year-old girl named Emerson, and a contested motion for parental rights that had turned into a series of legal feints and emotional flashpoints. The family court filing submitted by Doug Benefield on September 3, 2020, was detailed. He alleged that Ashley had exhibited what he described as paranoid behavior, increasingly erratic outbursts, and unjustified attempts to limit father-child contact. In his affidavit, Doug included several examples, most notably a July incident where he arrived for a scheduled visitation and was told by Ashley that Emerson was too upset to see him. According to his statement, this had happened 4 times that summer. The motion sought full physical custody, citing concern over Ashley's mental stability. Attached were text message screenshots from Ashley, sent between May and August, which read, in part, "You don't get to control me anymore," and "You won't take her from me, ever." Individually, these messages didn't prove a threat, but as part of a pattern, they suggested fixation. Ashley responded with a countersuit. She claimed Doug was manipulating the court system to punish her and gain full control of their daughter. Her own documentation included private journal entries, selected photos of Emerson, and references to conversations never independently verified. She also alleged that Doug's prior military discipline made him inflexible and prone to emotional pressure. But no physical abuse was claimed. No restraining order had ever been filed. The key turning point for investigators came when they reviewed the timeline. Doug filed for custody on September 3rd. Ashley was served notice on September 9th. Doug scheduled an in-person exchange visit for September 27th, the day he died. This alignment wasn't conjecture. It was calendar-based, confirmed by court servers and Google account timestamps. And while none of that proved intent, it introduced a direct correlation between legal pressure and a fatal encounter. Forensics analysts examined Ashley's recent digital history, cross-referencing her phone and laptop activity. In the 48 hours following the custody filing, her device accessed websites related to Florida child custody law, parental rights in contentious divorces, and Florida's Stand Your Ground statute. One search, dated September 10th, read, "Can I defend myself if I feel threatened but they haven't hit me?" Ashley had voluntarily surrendered her electronics, but the forensic team still performed a bit-level recovery. Deleted files revealed screenshots of custody case templates, samples of ex parte motions, and a list of emergency attorneys in the Sarasota area. These were not out of place given the situation, but the volume, detail, and timing stood out. There were no search terms related to de-escalation, no communication with mediators, no calendar entries for court-requested parenting classes, just legal strategy and case positioning. When the investigative team ran a cross-check of Ashley's activity on social media, they discovered that on September 13th, 2 weeks before the shooting, she posted a photo of herself with Emerson captioned, "You'll always be safe with me, always." The post had since been deleted, but data retrieval from Facebook's server backup provided a copy. It would be easy to interpret such statements emotionally, but investigators were not in the business of sentiment. They were in the business of sequencing behavior. The homicide unit submitted a request to speak with Ashley's former ballet colleagues. One dancer, who asked not to be named, stated during a phone interview, "Ashley didn't handle power shifts well. If she felt someone was taking something from her, she'd find a way to take it back." The comment was not used in court, but it became part of the behavioral file. Doug's side of the story, posthumously reconstructed through emails, was less reactive. His messages to his attorney were procedural, not emotional. He mentioned concern, yes, but always in terms of custody structure, not personal safety. One message, dated September 15th, stated, "Ashley's increasingly closed off. I think this is damaging to Emerson. I'm not angry. I just want a stable plan." Investigators reviewed the planned exchange on September 27th. There were no witnesses scheduled to attend. No neutral location had been designated. No law enforcement standby requested. Doug walked into the home unarmed, unaware, and expecting a routine interaction. There was no forensic evidence suggesting he initiated an altercation. The crime scene, as previously documented, showed no struggle. The autopsy report, now finalized, confirmed no abrasions or defensive wounds. Toxicology was negative. Doug had no alcohol, no sedatives, no substances of any kind in his bloodstream. One line from the ME report caught the detective's attention. Victim exhibited signs of being caught off guard. Wound pattern suggests he had little to no opportunity to react. In a procedural sense, that detail supported the earlier trajectory analysis. The first bullet hit him in the leg, not immediately fatal. The second, through the arm, into the heart, was fired seconds later. The spacing of blood droplets indicated he had likely turned or staggered before collapsing. The shooting sequence, digital patterns, and court activity all pointed in one direction. A pressure point had been reached. Whether or not the final act was premeditated would remain a matter for the court. But law enforcement wasn't guessing anymore. They were building a timeline, with evidence, not inference. Ashley had claimed fear. The evidence showed control. The autopsy report landed on the lead investigator's desk exactly 6 days after the shooting. It was routine procedure, but in this case, it was more than a formality. It was a control variable. A corpse never lies, and the sequence of internal trauma can sometimes tell more about the truth than any living witness. Dr. Evan Marks, a board-certified forensic pathologist, completed the examination of Douglas Benefield's body at the Manatee County Medical Examiner's Office. The report was precise, absent of interpretive language. It described 2 gunshot wounds, the first entering the right inner thigh, traveling through soft tissue and lodging against the femur, the second penetrating the left forearm before entering the thoracic cavity, piercing the lung, and damaging the right ventricle of the heart. The second wound caused immediate internal hemorrhaging and was declared the fatal injury. There were no signs of blunt force trauma, no contusions, defensive wounds, or fractured bones. Fingernails were intact. The stomach contents were partially digested chicken and broccoli, consistent with the timeline Doug had told his assistant. He planned to stop by for a brief dinner with his daughter. There was no alcohol in his system, no sedatives. The cause of death was officially listed as homicide by gunshot wound to the chest. The medical examiner's report didn't suggest motive, but it dismantled the claim of a violent struggle. The angle of entry on both wounds showed Doug was upright, possibly turning at the time of the second shot. There was no evidence he had closed distance on the shooter or even raised his arms in defense. The blood pattern analysis reinforced this. Droplet distribution across the tile floor showed limited motion between impacts. According to the trajectory maps prepared by ballistics experts, the shots were spaced by seconds, not milliseconds, which raised a new question: why a second round? The homicide team brought in an outside expert to confirm the findings, an independent forensic consultant with prior experience on officer-involved shootings. He reviewed the shell casing distances, powder residue findings, and projectile trajectory alongside the autopsy. His conclusion was succinct. The first round was non-fatal and likely immobilizing, the second fatal and precise. In plain terms, Doug had already been neutralized when the fatal shot was delivered. Detectives then re-reviewed Ashley's statement, that Doug charged at her, that she feared for her life. The physical evidence no longer supported that account. No forward momentum, no sign of physical engagement. Nothing in Doug's body or the environment corroborated a sudden or chaotic assault. From a forensic standpoint, the autopsy established an unbroken narrative. Doug was stationary. The shooter had line of sight, space, and time between each shot. The fatal shot was not delivered under duress. It was delivered with placement. Parallel to the autopsy findings, analysts continued their work on the digital forensic timeline. The home's router logs were reviewed by a cyber unit. The house, outfitted with smart lighting and appliance systems, gave off patterns. Every time a light switched, a timestamp was logged. The data showed no irregular activity from the time Doug entered until police arrived, except for one anomaly. The smart assistant device in the kitchen, an Alexa Echo Dot, was activated at 5:19 p.m. for 14 seconds. It had no stored command, but the device was triggered manually, not by voice. That activation coincided with the moment between the 2 gunshots, according to both body cam audio and digital clock sync. Investigators obtained a warrant to extract partial logs from Amazon. While no audio was retained, metadata confirmed the button had been pressed, not spoken to. No requests were made, just a manual push and silence. That raised an internal debate. Was the button hit unintentionally, or was someone trying to test whether it was recording? Ashley had not disclosed any contact with the device during her statements. When questioned in follow-up, she claimed she didn't know it had a mic. Investigators took note of the inconsistency, though it did not rise to a criminal threshold. Separately, the firearm was examined in full. It was a Smith & Wesson 9mm, legally owned by Ashley's mother. No prints on the grip, no oil transfer. The magazine had been removed post-firing and the chamber cleared. The weapon had been placed on a console table facing away from the body, not dropped, not tossed. The deliberate clearing of the weapon became a procedural inflection point. While Ashley had claimed panic, the presence of a post-discharge magazine release contradicted a reactive mindset. It reflected training, or at minimum, forethought. That finding, when presented to the homicide unit, re-centered the case around pre-action awareness, not post-action regret. There was no legal requirement to prove what Ashley knew about the weapons operation prior to the shooting, but internal notes referenced a 2019 email Ashley sent to a family friend, asking whether taking a basic handgun safety course was necessary to protect yourself legally. The course had not been completed, but the question was enough to reframe the issue. This wasn't a woman unfamiliar with firearm procedures. The final development came from a supplemental phone dump completed by the forensics lab. A deleted video file recovered from Ashley's phone showed her recording herself days before the shooting. It was a journal-style clip, timestamped September 24th, with her speaking directly into the camera. The content of the video was sealed from public release due to the ongoing prosecution, but internal memos confirmed the following phrase: "He doesn't get to win just because he has more power." The video had been erased prior to the shooting. Only partial recovery was possible. Still, its existence and timing were enough to be submitted under sealed evidence. The sum total of the autopsy, device behavior, and firearm examination reinforced a single forensic conclusion. There was no physical evidence Doug Benefield posed an imminent threat in the moment he was shot. There was no sign of a life-or-death struggle. But there were multiple indicators of awareness, spacing, and decisiveness on the part of the shooter. That's what elevated this chapter of the case. It wasn't what the scene showed. It was what it didn't show. No fear, no chaos, no accident. 16 days after the shooting, attorneys representing Ashley Benefield filed a motion for immunity under Florida's Stand Your Ground law. It wasn't unexpected. The legal team had been signaling the move from the moment Ashley gave her initial statement. The filing asserted that Doug Benefield's presence posed an imminent threat and that Ashley, fearing for her life, acted in lawful self-defense. If granted, the motion would terminate the prosecution before trial. No jury, no sentencing, just a ruling of immunity and a closed file. For the prosecution, the strategy was familiar, but the evidence didn't align with the statute's protections. Florida's Stand Your Ground law allows individuals to use deadly force if they reasonably believe it is necessary to prevent imminent death or great bodily harm. But the statute is rooted in immediacy. Inaction, delay, or disproportionate response can void its application. Prosecutors believe that's exactly what they had, a response that extended beyond necessity. To respond, the state began assembling a forensic legal timeline tailored to challenge the defense's claim of perceived threat. The backbone of their case wasn't one smoking gun. It was 10 separate, verifiable decisions made by Ashley in the hours, days, and weeks before the shooting. Each one indicated planning, control, or awareness inconsistent with spontaneous fear. The most direct piece of evidence came from the firearm itself. The weapon had not been fired in haste. After 2 rounds were discharged, Ashley manually ejected the magazine, cleared the chamber, and placed the gun on a table. That behavior did not suggest panic. It demonstrated procedure. Digital forensic logs showed that after the shooting, but before calling 911, Ashley had attempted to unlock Doug's phone. The attempt failed. Face ID did not recognize her. Investigators recovered this action from the iPhone's security log. It was time-stamped 5:25 p.m., 1 minute before she contacted emergency services. The question of motive was now layered with digital intent. If the threat had been neutralized and Doug was down, why reach for his phone? And why wait before calling for help? Further scrutiny of Ashley's actions came from location metadata extracted from her vehicle. The GPS log showed that 2 days prior to the shooting, she drove a loop past Doug's rental residence in Sarasota, twice in a single morning. She never exited, never called, no messages were sent. She did not mention the drive in any statement. Investigators were unsure whether it was surveillance or hesitation, but in context it marked another entry in a pattern of escalating preoccupation. Her legal team offered a different framing. They argued that the cumulative behavior was evidence of a woman trying to protect herself without legal recourse, that the court system had been too slow to address her concerns, that the steps she took were not signs of premeditation, but desperation. That interpretation, however, was undercut by testimony from a former friend who provided emails and messages contradicting Ashley's portrayal of events. In a message dated 1 week before the shooting, Ashley wrote, "He thinks he can scare me into surrendering. I won't let him win." The language wasn't frantic, it wasn't fearful, it was defiant. The immunity hearing was scheduled for late spring. It would be a bench ruling decided solely by a judge. No jury would weigh in. The legal standard was preponderance of the evidence, lower than criminal conviction but still requiring consistency, coherence, and proof that deadly force was proportionate to the threat. Prosecutors brought in a forensic psychologist to evaluate the tone and progression of Ashley's behavior. The expert never spoke directly to Ashley, but based conclusions on evidence submitted. The report stated that Ashley demonstrated high control orientation, pattern-seeking justification for confrontation, and anticipatory behavior in relation to threat perception. In more direct language, it meant she may have been expecting something to happen and preparing for it, not reacting in real time. The court denied the stand your ground motion. In a 4-page ruling, the judge wrote that the evidence failed to demonstrate an imminent threat at the time of the shooting. The ruling emphasized 3 points: the spacing between the shots, the lack of physical injuries, and Ashley's post-incident actions. The judge wrote, "The use of deadly force must be immediate and necessary. The evidence in this case shows a calculated response, not a defensive reflex." That decision cleared the path to a formal prosecution for manslaughter with a firearm, a charge that carried a maximum sentence of 30 years. Prosecutors weighed their options carefully. A conviction of second-degree murder was possible, but less certain given the relationship context and absence of a criminal record. Manslaughter, by contrast, offered a charge more consistent with overreach than cold intent. Ashley's defense team issued a public statement within hours. "This ruling does not mean our client is guilty. It simply means she will have the chance to present her full defense before a jury of her peers." The narrative would now shift from legal thresholds to trial strategy. For detectives, the immunity hearing marked a procedural milestone. The question was no longer whether the state had standing to prosecute. It was whether a jury would agree that fear had been used as a mask, one shaped by resentment, strategy, or control. With the stand your ground motion denied, the prosecution began refining its trial strategy. They weren't just building a timeline anymore. They were constructing a behavioral framework. It wasn't enough to show that the shooting wasn't necessary. They had to show that Ashley's mindset, actions, and prior statements weren't just reactive, but consistent with a person anticipating control loss and maneuvering around it. One focus was interpersonal history. A subpoena was issued for digital conversations between Ashley and 3 individuals who had remained close to her throughout the custody dispute. 2 cooperated. The third, a former colleague from the failed American National Ballet project, provided text chains that stretched back 2 years. These included screenshots where Ashley referred to Doug as calculating, obsessed with his image, and, most notably, easy to outthink. None of those messages proved intent, but prosecutors were no longer just looking at provocation. They were looking at pattern. In one instance, Ashley sent a message saying, "He doesn't understand what happens when I feel cornered." That message was dated during the early stages of their custody disagreements. It wasn't inflammatory enough to introduce as a threat, but it was flagged as an indicator of pre-escalation mentality. Behavioral forensic analysts brought in to advise on trial presentation focused on Ashley's conflict style. A review of 42 emails between Ashley and Doug over an 8-month span revealed a consistent tactic: reframing logistical issues as moral infractions. If Doug asked to modify a custody exchange by a few hours, the reply often emphasized betrayal or disrespect rather than scheduled logistics. This reframing, according to analysts, was significant not because of the emotion, but because of the insistence on control of the narrative. More immediately, prosecutors sought out live witnesses, people who had interacted with Ashley in the 2 weeks leading to Doug's death. That included her mother, a neighbor, and a friend who had visited the home the day before the shooting. The friend described Ashley as normal, just focused on legal stuff. No mention was made of threats, fear, or anxiety. In fact, the visitor stated that Ashley was preparing a new schedule draft to show her lawyer and seemed in charge of her plan. That testimony undercut any claim of emotional instability or erratic decision-making in the final hours before the incident. But the most telling statement came from Ashley's mother, who had left the house to walk the family dog shortly before the shooting. In her police interview, she said, "Ashley told me not to come back inside until she called me." When asked why, she said she didn't know. That comment didn't make its way into trial directly, but it was memorialized in the prosecution's notes. A simple request on the surface, but in the context of the shooting, it became a flag. Was it a coincidence, a way to prevent interruption, or a quiet precondition for what came next? From the defense side, The approach shifted toward mitigation. They began preparing character witnesses, friends and former dance associates, who would testify to Ashley's history of emotional abuse, postpartum struggle, and perception of being isolated in the marriage. These weren't evidence-based arguments. They were narrative tools, intended to reframe Ashley as someone who, even if not legally innocent, had been shaped by circumstance. But legal interpretation required more than character. It demanded coherence. The prosecution knew that jurors wouldn't convict solely on digital logs or phrases taken out of context. What they needed was a clear through line, a behavioral progression that made the shooting not just questionable, but disproportionate. They leaned on the forensic psychologist again. This time, the analyst prepared a briefing document explaining how anticipation, when paired with control-seeking behavior, could simulate threat perception, not fabricated, but exaggerated. The theory wasn't that Ashley had lied. It was that her lens was skewed, that in seeking to preserve custody, she had come to see control as safety, and any loss of that control as a crisis. The report was careful not to label Ashley clinically. No diagnosis, just language drawn from behavioral science. An escalating threat model, where relational challenges are interpreted as personal jeopardy. What this meant for trial was simple. The prosecution could now argue that Ashley's fear wasn't fear of physical harm. It was fear of losing authority. And Florida law, while broad in its self-defense protections, does not justify homicide based on fear of emotional displacement. As both sides neared jury selection, these foundational arguments took shape. The case was no longer about what happened in the room alone. It was about everything that led to it, and the lens through which the shooter interpreted consequence. Jury selection began quietly. There was no media circus, no national spotlight. But inside the courtroom, tension was managed with precision. The prosecution opened with the timeline: a custody dispute, a single gun, 2 bullets, and a body with no signs of resistance. The defense responded with framing: an overwhelmed mother, legal pressure, a system that failed to protect her. 12 jurors were sworn in, 5 women and 7 men. Each had been screened for bias toward self-defense laws, trauma experience, and preconceptions about domestic violence. Both sides agreed on one thing: the courtroom was not the place for speculation. Facts, not feelings. Over 6 days, the prosecution called 21 witnesses. A forensic pathologist testified to the trajectory and spacing of the shots. A digital forensic analyst confirmed the phone unlock attempt immediately after Doug was shot. A smart home expert outlined the unexplained Alexa activation. None of these points were sensational, but they were surgical. Each one chipped away at the foundation of panic. On the 4th day, the defense called a clinical psychologist. She had interviewed Ashley in pre-trial sessions and testified that Ashley exhibited signs of post-traumatic hypervigilance, a condition often linked to survivors of long-term psychological abuse. She stated, her nervous system was trained to respond with heightened threat detection, even in low-risk scenarios. The prosecution cross-examined, but was there any medical diagnosis of abuse in this relationship? The expert answered, no. Was there any protective order, police report, or hospitalization tied to domestic violence? No, she said again. That sequence would later be cited by multiple jurors as pivotal. Doug's attorney had also been called. He testified that Doug had expressed concern for custody fairness, not physical safety. He believed in process, the attorney said. He wanted the court to resolve it. The most anticipated witness never took the stand. Ashley declined to testify. The defense framed it as a legal decision to avoid emotional misinterpretation. The prosecution allowed it to stand unchallenged. In closing, the prosecutor returned to evidence. Not motive, not moral character, just sequence. There were seconds between those shots, enough time to stop, enough time to choose a different outcome. The jury deliberated for 9 hours over 2 days. When they returned, the verdict was unanimous: guilty of manslaughter with a firearm. Not murder, not exoneration. A middle ground supported by law and weighted by fact. The sentencing hearing came 3 weeks later. Ashley appeared in court wearing standard issue beige. Her expression was flat. She declined to speak. The judge, referencing both aggravating and mitigating factors, imposed the maximum: 20 years in state prison, followed by 10 years of supervised release. Doug's mother delivered the victim impact statement. She spoke briefly. My son's life ended not with violence, but with calculation. That's what I can't forgive. Following the verdict, Custody of Emerson was granted to Doug's adult daughter from his first marriage. Ashley's parental rights were not fully terminated, but visitation would require future psychological evaluation and court oversight. In legal circles, the case became a discussion point on Florida's self-defense statute. Analysts questioned how easily narrative construction could be used to blur legal thresholds. The prosecution team declined to comment on any political implications. Their internal memo simply concluded, the law was tested, the evidence held. What remained was not sensational. No breaking headline, no confession, just a closed file and a child left with two families and no parents. The final page of the case report noted the following. Weapon, Smith & Wesson, 9mm shots fired, 2 fatal rounds shot, 2 motive, not fully established verdict, manslaughter sentence, 20 years. Some cases end with a trial. Others leave residue, policy debates, ethical divisions, and private consequences. In the Benefield case, the facts were clear, but the emotions were not. And maybe that's where justice often lives, not in certainty, but in conclusion. Sometimes justice isn't about vengeance, it's about clarity. Looking back, I've learned that fear, when left unexamined, can become its own justification. But fear is not the same as danger, and instinct is not the same as law. If there's one thing I hope you take away from this story, it's this. Learn to question your emotions before they define your decisions. No outcome can reverse what happened, but maybe understanding it can prevent the next. Do you think self-defense laws should be reevaluated? Have you or someone you know faced a moment where perception clashed with reality? I'd love to hear your thoughts in the comments. If this story made you pause, reflect, or feel something real, let me know where you're watching from or what stood out most to you. And if not, I still want to know what didn't connect with you. If you found value in this video, please subscribe to the channel so you don't miss the next case we uncover together.